Welcome to the Snowbirds Expat Radio Podcast, powered by the Snowbird US Day Tracker app. I'm your host, Gerry Scott, and my goal is to give you answers to your cross-border questions, to ease the stress of a cross-border move or extended trip, and to keep you up to date on all you need to know with cross-border rules and regulations. Now let's get on with the show. Well, welcome everybody to the Snowbirds Expat Radio Podcast. Today is going to be really interesting. Today's podcast, and I'll introduce my guest in a second here, it is going to be based on mom and dad have lived in Canada all their life. Their beautiful children have moved down to the States, and all that complexities that have been created because now mom and dad have passed away within the last 2 years, and trying to deal with this estate is so complex. And I'm happy to say today we have Carol Sadler from Achen Henderson out of Calgary. And we were fortunate I think it was about 8 months ago, Carson and I flew out to Calgary and we brought a bunch of donuts in, and we had a great visit with Carol and one other partner at the firm. So Carol, welcome to the show. Tell us more about yourself and more about Achen Henderson.
I will, and then we can dive into these complex situations. We've got a team of people who are both Canadian CPAs and US CPAs, so that's essentially where we can help and try to make things easier for those cross-border situations. We're licensed on both sides of the border, and that's what we do is figure out that kind of like that Venn diagram where everything meets in the middle. And both countries want to tax you not just one, but two, and God forbid, maybe more somewhere in different ways. So that's been my background for a number of years, is working in that cross-border area, down in just south of downtown in Calgary, close to the mountains. We have snow today. It'll go though.
You know, I have a brother that lives in Calgary, and he was telling me that they had eight inches of snow, and they live in an area called Mahogany, which is new development. I was told that there's no waterfront property left, but apparently they dug a big hole and it filled up with water, and now they all got waterfront property in Mahogany. So let me set this up again. Mom and dad have lived in Canada their entire life. Their children in their 20s moved away. They've, they both became U.S. citizens. And now we're dealing with this very, very, very complex situation. And just, you've got the grounds of what we're discussing here, so let's run with it. Tell us that, and I got to tell you, Carol, this is so confusing that one of the professionals, one of the daughters, who's in tax, was blown away how complex this was, dealing with U.S. people not being able to be an executor on mom and dad's estate. But then all her friends and family, these other Canadians down in the States that are going through the same thing, there's very little help available. So there you are.
That is true. Generally, most of us accountants and lawyers, tax lawyers and estate lawyers are generally practicing in one country or in the other. But it's when you cross that you need to know what happens between both. In this case, now I've seen this a lot. I think it'd be very common. Mom and dad would have wills where the children are generally the executors, because that's often what mom and dad do. And either they haven't updated their wills for a while, or just didn't think about the fact that the children are now U.S. persons. And it's actually not. There is nothing under law that says, thou shalt not be an executor if you are not a Canadian person, but it makes things difficult. There are a lot of things an executor has to attend to possibly sign in person, and a lot of Canadian provinces will require a bond from a person who doesn't live in the States. Basically, what the government is worried about is that a non-resident executor is someone they can't reach out to, they don't have any jurisdiction on. What if this non-resident executor scoops all the funds and is in the U.S. and Canada can't help? I do work with estate and trust lawyers who can work with that situation, but just just to begin with, it's problematic. I mean, a bond means tying up a whole bunch of money for a bunch of time till the estate has settled. It's going to be complex. That's going to take a while. What some people do in that case is appoint a Canadian trust company, either jointly with a U.S. person or where there's language in the will or attachment that says that pick your favorite trust company, basically, without mentioning the big banks have them. There's some really good independent trust groups out there. They're Canadian, so that Canadian entity solves that U.S. problem. But I know we've even had clients, I want a family member involved. I don't want to leave everything, even though I think my will might express my wishes. I want a member of the family involved. So you can either have them as co-executor or leave some wish to say that on these sorts of matters, I wish the beneficiaries to be consulted. So that is one possible solution. In the case we're talking about here, that ship might have sailed, because that, of course, has to happen in the will. And if the will says daughters are, one or the other daughter is executor or both are co-trustees, one solution might be to apply for those people to decline being trustees or executor and ask the courts to appoint a trust company. So that's one solution.
So you like that. You like it when it's a complex like this, that it makes a lot of sense. Not to mention Solus Trust. Little plug in for my friends at Solus Trust.
No, that's, yeah.
But you do recommend that these trust companies could really allow this to be a lot smoother and less stressful than that person in the States trying to navigate these complexities.
That's it. As you mentioned, the one person had lots of help, but they could have lots of help, is knowledgeable, but is knowledgeable in what happens in California, not in Alberta or Ontario. And so, like I said, it's not impossible, but it's a lot of work for that executor. That executor may have to travel up to Canada a great deal to sign documents. The bond we'll need Canadian legal counsel anyhow. The bond can be problematic, as I said. That's just tying up a bunch of assets, and that the courts may or may not waive that. So even a co-trustee arrangement or some wishes that will help that. So that's one way. That's one way to start the process.
Okay, so the things that I'm aware of is that there is a difference between, in Canada we have what we call a death tax. United States has what they call an estate tax, and then there's a treaty to try and to kind of maneuver this double taxation. So tell me the difference between death tax and a U.S. estate tax.
Absolutely. Now, the mom and dad are particularly on for the second to pass away are going to face Canada's death tax, and that's a deemed disposition of assets. It's as if you sold everything at that moment of death and got all the money. Of course, that hasn't happened, but you're taxed as if. So principal residence, if there still was one, is deemed sold. Particularly investments are deemed sold at fair market value at that date. Any RIF or RSP are fully brought into income, and that can cause a big tax bill. So if you've got, people often are deceased with large RIFs. You've got hundreds of thousands of dollars still left in the RIF or RSP. That is all taxed as if all that occurred at the date of death on the last personal tax return of that individual, and the tax is due. Tax is due next April 30th. Now, in the U.S., the deceased is also taxed, but the difference is there's a tax on the value of the assets, not on gain in the assets, which is Canada, but the shopping list or laundry list, if you will, of all those assets. I have these assets in my RIF or RSP. I have these non-registered assets. I have this house. I have this cottage. I have these various other things. But right now, there's a very large estate tax exemption. It's 13 million US, so what will that be? Call it 18 million Canadian. And no worries. And mom and dad will, if they're not U.S. citizens or green card holders or didn't have any U.S. property, they will not have to file anything for estate tax. They might if they owned U.S. securities, so either U.S. vacation property or U.S. securities. Those are two of the most common things I see that would cause Canadian mom and dad to have to file an estate tax return. Now, Canadians under the treaty are afforded that $13 million exemption. So if we say mom and dad have a net worth of 10 million Canadian, there are a couple million, let's say there's $1 million of U.S. securities in their portfolio. The filing of you'll have to file a state tax return, but it's essentially a formality to claim that. And the reason you have to do that is the IRS won't grant the exemption to Canadians as it's allowed under the tax treaty unless they get a form.
Now, what about final returns for that U.S. person? And I know that now the other thing I remember by experience is that mom and dad, it doesn't make sense for them to be put on as beneficiaries as well. They name the estate just to avoid PFIC and different issues as well. Any thoughts around that?
Basically, the short story is that I'm in agreement. Maybe I'll step back a sec, and it'll make a bit more sense perhaps why when I walk through the returns. So I'd mentioned the death tax in Canada is a deemed disposition of everything you own essentially that can be taxed. I mean, I'm a little exaggerating a bit there, but assets essentially on a final return. So you have a Canadian tax return, personal tax return with all the income to the date of death, plus this deemed disposition. That is the last personal tax return filed by that individual. So say mom was deceased first, everything went to dad, dad's deceased now, everything disposed of in the return plus his income. That is where his individual personal filing responsibility stops, and an estate or trust, and those two are technically interchangeable in Canada, is created. Now maybe, and let me just step in for a sec and say, I'd mentioned in the U.S. there's an estate tax, which is a tax on the value of the estate, not the gains in the estate. It's a separate filing. So Canada combines two in one. And the U.S. based, so if one of those, say dad was a U.S. person, he'd be filing a tax return only on his U.S. income, that he'd stop, he'd file an estate tax. That would stop. End of story for personal tax. An estate is created with the estate tax return. So back to our estate in Canada. So now we have this new entity, if you will, being created under law that holds all the assets, and essentially it's going to exist until essentially all the assets have been distributed or are in a position to be distributed. Practically, it means when there's only cash left and we're checking to make sure that all returns are filed, the tax is paid, so on and so forth. The difficulty that can occur there is that the U.S. has this definition of a PFIC, or a passive foreign holding company, and that the definition extends a lot more than you think those words might cover. It sounds like, oh, if I have a company somewhere, then maybe those rules apply. But the difficulty is they extend further than that. A really quick definition, what the U.S. is trying to guard against there is someone who lives in the U.S. Say one of those daughters had this way maybe to look at it. One of those daughters has a company in, gosh, it could be the Bahamas, it could be in Switzerland, it could be Canada. I joke that Canada is a tax haven to the U.S. It's outside Canada. There's this company, and because it's foreign, it's not giving any income or reporting any income to the U.S. person. The U.S. person isn't paying any tax. The IRS says, well, if you own those assets personally, then you'd be paying tax on some of the income from those assets. Now you're not. We want some reporting of that of that entity. So one other concern, the PFIC concern is daughters are executors of the will, trustees of the estate that has been created under the will. And it is foreign. It's foreign because mom and dad lived in Canada. Their will was a Canadian will. The U.S. doesn't have so it's foreign. U.S. does not have jurisdiction, even though you have some U.S. perhaps executors or trustees. The U.S. courts do not have jurisdiction over that will. It's foreign to the U.S. So now we have U.S. individuals who have control of a foreign entity, and that's where the corp is misleading. The IRS has said that some trusts could be considered PFICs. They are somewhat unclear as to what. It's interesting. Mutual funds are considered. Canadian mutual funds are considered PFICs, and if you take that definition, and there's tons of backstory there I will not get into at this point. That'd take us hours. There is that concern that the IRS would go, oh, you beneficiaries and particularly being executors more so than beneficiaries. Oh, you control these you control this trust. Is this a PFIC perhaps? And if so, there's a concern when they are allocated any income. That's the issue with the PFIC is allocations of income to those beneficiaries, executors who are also beneficiaries. So a bit of a legal definition there to keep in mind because maybe they're not. In this case, they're one and the same. That's very common. If income is allocated to them, there can be a U.S. tax issue for them. Higher rates of tax, a lot more reporting. So then we have to be very careful about what occurs in the estate. We want to make sure we don't distribute income to those beneficiaries. We want to distribute, basically, in a lot of cases, what we want to do is sell those investments fairly quickly, monetize everything, give them cash. That will minimize, there'll still be some reporting for them, but that will minimize some of the problems. Not all, but that's the best way to handle that issue.
You know, it's interesting when we talk about cross-border and all these issues where you almost have to, I relate to on the Achen Henderson website, I see a picture of Clayton with a guitar. And every time you pick up a guitar and put it in your hands, you see these famous guitar players are always closing their eyes because they got to be so focused when you talk about if you're playing guitar, excuse me, or you're talking about cross-border estate. You really got to slow everything down and get so focused. It's so complicated. So here's another situation. So when this estate is being settled and the assets are being distributed, not income, but assets are being distributed. There's a clearance certificate from CRA that has to be issued as well. When does that come in after the filing, or when does that clearing certificate come into play?
That comes into play at the point where we know what the final distribution of assets will be. So practically, that's usually when there is cash left. There could have been interim distributions, but there's basically cash left. We're pretty certain of the tax, that the taxes have been paid, that the returns have been filed, that there's only cash left, and we're in a position to tell CRA about what we've done, and that essentially this is what's left. We're in a position to make a final distribution as soon as we get that clearance.
Okay. Okay.
So yeah.
Yeah. So here's something else that comes up a lot, and when we're seeing parents having multiple marriages, we're seeing a lot of alter ego trusts after the age of 65. We're seeing that second mom or second spouse, the assets are being set up in a spousal trust. How does that complicate those beneficiaries of dad's estate when mom has passed and dad has moved on with a second wife?
You're creating trusts under the will that are going to survive that windup of the estate. So as if you're essentially saying you're partitioning your estate, if that makes sense. Like, beneficiaries, daughter beneficiaries in the U.S., here's what goes to you. But there are some assets that are left in a trust that is going to probably exist for some time. In a lot of cases, what will happen with spousal trust, it's a matter of, say, I'm putting perhaps our home, maybe vacation property, maybe certain securities in a trust for second wife. And she can use certain amounts of capital for certain things. She can use the income for certain things. But the idea is we're taking care of second wife when she's deceased now, daughters or other children or other beneficiaries, now you can claim, you can get the remainder now. So it's often a way to provide for blended families in certain ways. We're going to set aside these assets for you. So now you've got the same issue of foreign trustees. If, say, daughters are going to be the trustees of that trust, as you had in the will, and that's going to continue perhaps for some years. Mom might be around for quite some time. So other Canadian trustees, co-trustees, the corporate trustees are answers to that issue, because you now have that issue of U.S. people are going to find it difficult to deal with a Canadian trust.
Interesting. Well, I'll tell you, this is, being in this cross-border space as many years as you have and I have, I mean, the biggest advice I can get people, and this is the purpose of this podcast, it's not a do-it-yourself podcast. There's nothing you can take away to think that you're going to be so much, it's easy. So we always tell people the purpose of the podcast is to educate people, but more importantly, connect them with the proper professionals, maybe Carol in Calgary. So that's the focus of these podcasts. Now, before we wind this up, because I know you're very busy and I'm very fortunate that I've been able to grab your time this afternoon, how do people get a hold of you?
One of the best ways is our website, because all our contact information is there. So I guess Google, look for Achen, Achen Henderson, which is spelled like it sounds. Our website is just that, www.achenhenderson.ca. My business partners have long names. If we thought about it earlier, we would have maybe done something else, but we didn't. So there we are, and that's probably the best way.
Okay, and I have to let people know that this is just the first part. These are mom and dad living in Canada. The kids have moved south, carried on their lives. Now we're going to be doing a second podcast with Carol, and it's going to be mom and dad live in the States, and the kids have moved up to this beautiful country we call Canada. So, Carol, we look forward to that opportunity to speak about the flip side of it. But once again, thank you for your time, and I really appreciate having a chance to speak about complex estate planning.
Thank you for the opportunity. I'm really, really glad to do it. As you can tell, it's something I like to talk about and teach people about, so I'm glad we could do it.
Thank you again for listening to the Snowbird Expat Radio Podcast. The best way you can support the podcast is to forward the episode to a friend, and please don't hesitate to like, subscribe, or leave a comment. Now, before you go, let me leave you with one of my favorite quotes. Be kind to all, the world is small.